Welcome to the Explainer. Today we're going to unpack a really fascinating court case that asks a fundamental question about the contracts we sign every single day. So let's just start with this question, because the answer might actually surprise you. Can a signed contract just not count? It's right at the heart of the story we're about to get into. Okay, let's dive in. Here's our roadmap. We'll see how a deal gets struck, then watch as some shocking news from a delivery driver turns everything upside down. We'll look at what it means to sign something under duress, see what happened in court, and then really dig into this idea of economic duress and where the final line was drawn.
So, our story kicks off in the world of commerce with what seemed like a totally straightforward win-win kind of deal.
First up, let's meet our protagonist, Kafco. Now, this is a small business. They make handmade baskets. And they have just landed a massive contract to supply goods to a major retailer, Woolworths. I mean, for a small company, this is the big break. This is everything. All right, so to fulfill this huge order, Kafco obviously needs to get the baskets to the stores. So they hire Atlas Express, a big player in the shipping world, a well-known national carrier, to handle all their deliveries. Seems like a solid plan, right? But just as things were getting started, the seemingly solid ground of their agreement just started to shake. A routine pickup was about to turn into a full-blown crisis. You see, behind the scenes, Atlas quickly realized they'd made a pretty big mistake. They had miscalculated and priced the delivery job far, far too low. Basically, this contract was going to cost them money. So what happens next is pretty wild. An Atlas driver shows up at Kafka's warehouse. But he's not just there with an empty truck. He's there with an ultimatum. He presents a brand new contract with new terms and delivers this stunning threat. And just look at the difference here. We are not talking about a minor adjustment. The original deal was a set price per carton. The new demand, a minimum charge that was drastically higher. This was a completely different deal and a much, much more expensive one.
This ultimatum just created an incredible pressure cooker moment for Kafco. They were suddenly and completely backed into a corner with an impossible choice to make.
And you can see here just how quickly this whole thing went down. The deal is signed, the first pickup is scheduled, and then bam, the driver shows up with his ultimatum, all while the deadline to deliver to their biggest client is just looming. The clock is ticking.
I mean, think about the position they were in. The stakes were incredibly high. They had zero time to find another carrier. Their massive new client, Woolworths, was at risk. Their whole reputation was on the line. And of course, this could lead to a catastrophic financial loss. We're talking about something that could literally bankrupt the company. So what does Kafco's director do? Feeling completely trapped, he signs the new agreement. But, and this is absolutely crucial, he writes two little words right next to his name: under duress. He's making it crystal clear that he is being forced to do this. So Kafco gets the baskets delivered, but later they refuse to pay that insanely inflated price. And as you can probably guess, Atlas Express sued them for the money, which is what brings this whole explosive dispute into a courtroom. In court, Atlas's argument was pretty simple, right? Hey, a contract's a contract. You signed it, pay up. But Kafco's entire defense, their whole case, rested on that one critical concept, those two words, under duress. And this brings us to the legal heart of the story, a principle called economic duress. It's basically a rule designed to ensure fairness in business and stop the big guys from just bullying the little guys with financial pressure. So what is it exactly? Well, economic duress is when one side puts so much unlawful financial pressure on the other that it basically forces them to do something they would never normally agree to. It's coercion, but with money and business as the weapon.
Now, to prove this in court, you usually have to pass a two-part test. First, was there illegitimate pressure? Like threatening to break your first contract. And second, did that pressure basically take away any real choice? Did it compel the will, as the lawyers like to say?
Think of it like this, right? Imagine you're locked out of your house in a blizzard. There's only one locksmith in town, and he sees your situation and demands 10 times the normal price. Do you have a real choice? No, not really. The law recognizes that consent without a real alternative isn't consent at all. So, the big question is, how did the judge apply this idea to the showdown between Kafco, the small basket maker, and Atlas, the giant delivery company? Well, the verdict was a huge win for Kafco. The court completely sided with them. The judge ruled that the new contract was void, totally invalid, because of economic duress. Atlas had illegitimately cornered them, leaving them with no reasonable alternative, and that's just not allowed.
And this is why this case is so important. The takeaway here is profound. A signature on a piece of paper isn't enough if genuine consent is missing. The law draws a really important line between hard bargaining, which is fine, and illegitimate pressure, which is not.
And that leaves us with this final thought, a question that every single person in business has to think about. Where exactly is that line? Where does tough negotiation end and illegal pressure begin? It's a critical question to ponder long after this explainer is over.